In today's topic, we will covering Lesson 1.2 Types of U.S. Law found in our business law textbook. The goals are to identify the four sources of law and distinguish between criminal and civil laws and between procedural and substantive laws. Sources of law include constitutions, statutes, administrative regulations, and case law. A constitution is a document that sets forth the framework of a government and its relationship to the people it governs. When constitutions are adopted or amended, or when courts interpret constitutions, constitutional law is made. The U.S. Bill of Rights is based on three English documents: Magna Carta, 1215, Petition of Right, 1628, Bill of Rights, 1689. Branches of U.S. government and lawmaking powers. Legislative branch makes the laws. Executive branch investigates and prosecutes alleged violators. Judicial branch sits in judgment of alleged violators. The federal Constitution created the Congress of the United States. State constitutions created the state legislatures. These state and federal legislatures are composed of elected representatives of the people. Acting for their citizens, these legislatures enact laws called statutes. All states delegate some legislative authority to local governments. Thus, towns, cities, and counties can legislate on matters over which the state has given them authority. Such laws are effective only within the boundary of the local governments that enact them. Such legislation is created by a town or city council, or by a county board or commission. Legislation at the local level usually is called an ordinance. Federal, state, and local legislatures all create administrative agencies. Administrative agencies are governmental bodies formed to carry out particular laws. The Federal Social Security Administration, your state's Division of Motor Vehicles, your county's Zoning Commission, and your city's Health Department are examples of administrative agencies. Although the agencies are created by legislatures, the executive branch of government usually controls administrative agencies. Thus, the president, governor, chief commissioner, or mayor will supervise the agency's activities. Legislatures sometimes give administrative agencies legislative powers and limited judicial powers. Legislative power means the agency is authorized to create administrative laws, also called rules and regulations. For example, the Federal Social Security Administration might set rules for determining when a student is a dependent of a widow or widower and qualified to receive Social Security payments. If an agency has judicial power, it can hold hearings, make determinations of fact, and apply the law to particular cases. The Social Security Administration might, for example, hold a hearing that decides whether a particular student is in fact a dependent. The courts have held that the rules and regulations made by agencies have the force of law. Thus, our body of laws is being constantly added to, not only by Congress and the state legislatures, but also by the multitude of state and federal agencies exercising the legislative powers delegated to them. All federal laws, even those made by agencies, are constitutionally supreme when in conflict with state laws.
The judicial branch of governments creates case law. Case law usually is made after a trial has ended, and one of the parties has appealed to a higher court. This appeal will be based on legal rulings made by the lower court in deciding the case. When the higher or appellate court publishes its opinion on a case, that opinion may state new rules to be used in deciding the case and others like it. These rules are known as case law. Federal courts establish federal case law. Similarly, each state creates case law through its state courts. The effectiveness of case law arises out of the doctrine of stare decisis, which is Latin for to adhere to decided cases. This doctrine requires that lower courts follow established case law in deciding similar cases. The doctrine of stare decisis generally does not bind Supreme Courts. However, even at the Supreme Court level, established case laws, known as precedents, are only changed after in-depth consideration. Classification of laws: civil laws, criminal laws, procedural laws, and substantive laws. When the private legal rights of an individual are violated, the matter is governed by civil law. The use of the term civil law within the common law system refers to the group of laws that deal with wrongs against individual persons. Civil law applies whenever one person has a right to sue or to bring legal action against another person. For example, when a tenant fails to pay the rent, the landlord has the right to sue the tenant. The police do not take action in civil conflicts. If a defendant loses a civil case, that defendant is liable. This means that she, he, or it, a business can sue and be sued, must do what the court orders so as to restore the plaintiff to his, her, or its pre-injury state. The payment of money damages is the remedy most often ordered by courts to accomplish this. A crime is an offense against society. It disrupts the stable environment that makes civilization work. So, when the citizen's right to live in peace is violated by such activity, the offense is governed by criminal law. Acting in the name of all the people, the government investigates an alleged wrongdoing. If a crime is committed, and the person responsible can be found, the government will prosecute. Conviction of a crime can result in a fine, imprisonment, and in some states, execution. Usually when a crime occurs, private rights of the victim are also violated. A violation may be both a criminal and a civil offense. Thus, the civil law may also apply. The victim of the crime may sue the wrongdoer in addition to bringing criminal charges against the same party. Procedural law deals with methods of enforcing legal rights and duties. Laws that specify how and when police can make arrests, and what methods can be used in a trial are procedural laws. Procedural laws determine what remedies are available in a lawsuit. The doctrine of stare decisis is a procedural law. Rules for determining the supremacy of conflicting laws are procedural laws. There are two types of procedural law: civil procedure and criminal procedure. Criminal procedure defines the process for enforcing the law when someone is charged with a crime. Civil procedure is used when a civil law has been violated. Civil law is concerned only with private offenses. When a civil law is violated, the injured party will follow civil procedure to seek compensation for his or her loss. Police and public prosecutors usually do not get involved in private disputes. In contrast, substantive law defines rights and duties. It is concerned with all rules of conduct, except those involved in enforcement. Substantive laws define offenses, such as murder, theft, vehicular homicide, breach of contract, and negligence.